Good afternoon. Welcome to an oral argument session of the 6th District Court of Appeal. My name is Mary Nardella. I'm joined today on the panel by Judge Joshua Mize and Judge Carrie Ann Wozniak. We have two cases to be heard this afternoon. The first is Michelle Mascaluna as spouse and survivor and personal representative of the estate of Michael Mascalunas versus Lakeland Regional Medical Center, John Zetti and Bruce Myers. Each side will be given 20 minutes to make their argument. Appellant, we typically reserve 5 minutes for your rebuttal, but if you would like a different increment of time, let the court know and we can do that. Is 5 sufficient? Okay. Whenever you're ready, you may proceed.
My name is Jean Penny, and I represent Mrs. Mascalunas, who is the plaintiff below, and her as personal representative and surviving spouse for the claim of her husband, the death of her husband for medical malpractice and wrongful death. The issue on appeal is whether the trial court erred in applying section 768-381 retroactively to the claims which accrued prior to the enactment of the statute. Our claim on appeal is that the trial court did in fact err in applying the statute retroactively because the statute is a substantive statute attaching new legal consequences to events that were completed prior to the enactment of the statute.
Counsel, when we determine whether or not the statute is substantive or procedural, do we look at the statute as a whole or do we look at its individual part that's
as a whole? This court has thoroughly analyzed the two-part step and the manner in which the statute is analyzed in the Hughes versus
the language in this act is pretty different than the language in Hughes, right?
Yes, the language is different, but our argument is that this is a much more substantial statute affecting rights than the statute in Hughes.
Well, but how substantial the statute is, does that factor into how clear the language is in terms of showing retroactive intent? Like, is there some rule that if a statute is a bigger, more substantial statute, the language has to be even more clear for retroactive intent?
Well, for the first step is whether statute intended to apply retroactively, and there, I guess the legislative intent, it doesn't matter, more or less in terms of what the statute actually does. The intent is clear or not clear. But in terms of whether the statute affects substantive rights that had attached, then, either there are substantive rights that were affected, vested rights, or there aren't. The degree to which they're affected, I don't think really plays into the constitutional analysis. If they're substantial, if the statute's substantive and it affects vested legal rights, then it's unconstitutional to apply it retroactively.
If there's procedural aspects and substantive aspects, let's say there's 9 procedural and 1 substantive, does that substantive one override everything else and make the whole statute substantive under your analysis?
Yes, under my analysis, and I believe under the analysis that set forth in the Menendez case by the Florida Supreme Court and then followed very strictly by this court in Hughes, that if it's substantive and it affects those legal rights that have already accrued and vested, then it's unconstitutional to apply it retroactively. In this case, that not only did it affect substantive rights or vested rights, it extinguished her cause of action for negligence. That retroactive application of the statute.
Because I see 2 bases to say that it extinguished your cause of action. 2 potential bases. I'm not saying I agree, but one is the fact that it turned negligence into gross negligence. And then one is the statute of limitations. At least the statute of limitations part of that seems to be controlled by Bull to me.
Well,
it didn't extinguish it. It changed the time period.
Except it only changed it. So the time period for a negligence claim is not changed. So you still have the same time period for the statute of limitations for negligence that there was before. It just changed the statute of limitations if you had a COVID related claim,
Correct, so it changed it for a subset of negligence claims. If you can,
gross negligence.
yeah, well, it's a separate issue, right? The fact that it changed from negligence to gross negligence, I'm kind of separating that out right now. Just the statute of limitations, it took one particular subset of claims and reduced the statute of limitations. It still reduced the statute of limitations, right? Bold said that's okay, didn't it?
Well, the way that I read bold in our argument is that bold applied to a particular cause of action. And that if you can change the statute of limitations for that particular cause of action. But here you added additional elements, so.
Okay, but those seem to me to be two separate issues, right?
Okay.
So I'm
Yeah.
not,
Mhm.
I agree that's a distinction.
Mhm.
It just seems to be separate. Just on the statute of limitations part. Old seems to say you can reduce the statute of limitations. I'm not saying that doesn't mean that gross negligence thing isn't an issue.
If you give it a reasonable time, you can
Correct.
change it, so,
In this case, your client had a year, right? At least a year.
a year after the enactment of the statute.
Right. And
That-
the
that
court
was
has
the
said that's a reasonable, the court has said that's a reasonable.
Reasonable time, right?
So it seems at least the statute of limitations issue. It seems to me that's controlled by Gould, isn't it?
Well, if you separate it out and you take out if you didn't add the, the COVID-19 issue and you didn't add the gross negligence issue, then if you separate all that out, then bold would apply, but you can't really separate all that out.
Well, I think you could though, right? I mean, I think whether or not you could reduce the statute of limitations is one issue, right? And then a second issue would be, can you change the level of culpability? And this is one thing I found a little confusing in the briefing because both sides characterize the change as changing the burden of proof, which is just obviously wrong, right? When you change from negligence to gross negligence, negligence is not a burden of proof, nor is gross negligence. That is a level of culpability. The burden of proof is preponderance of the evidence, right? Or clear and convincing evidence. So the burden of proof is the burden, the level of evidence by which you prove a substantive cause of action or a substantive level of culpability. So, we have preponderance of the evidence, right? Clear and convincing evidence, reasonable doubt. Those are burdens of proof. Negligence and gross negligence are not burdens of proof. Both sides seem to have characterized it that way, which to me was really damaging to your case because there's lots of evidence, there's cases that say burden of proofs are in fact procedural, right? So if it is a burden of proof, which is how you characterized it, it would seem to me you lose, right? But it's actually very clearly not a burden of proof. Negligence and gross negligence are not the burden of proof. Preponderance of the evidence is the burden of proof, and that part didn't change.
It's a good point. The statute says it's the standard of proof, which, I guess that you make an excellent point there. that
The context in which the cases said that burden of proof is procedural, they were referring to the burdens of proof at which you prove something at trial,
Mhm.
right? None of them referred to the level of culpability here.
So changing.
Those cases are just in a posit, right?
Mhm.
If you change from preponderance of the evidence to say clear and convincing evidence, the case law says that's procedural and that's a burden of proof. And I understand there's some statutory language here that says the standard of proof, but that's not what was at issue in those cases that found burdens of proof procedural.
Right. Well, that's an excellent point because what was changed was far more than the burden of proof.
Well, what do we do with
Extinguished or
the-
negligent.
What do we do with the fact that you stipulated, you affirmatively argued on appeal, this was a burden of proof issue?
Well, we argued on appeal that the statute cannot be applied retroactively because it unconstitutionally affected the vested rights that had accrued prior to the enactment of the statute. So that argument is a valid argument, whether it was characterized, her rights were affected regardless of whether the argument was framed in terms of a burden of proof rather than a cause of action. So the fact Mrs. Mascalunas had a cause of action that survived a motion to dismiss prior to the application of the statute. After the application of the statute, she no longer had, her cause of action was extinguished. And that was an unconstitutional application retroactively of this statute.
Let me ask you, if you separate out the two issues, if I take your point about the, I think you could have a presentation problem with the way you presented it, but if I take your point about you had a negligence cause of action and they eliminated it and turned it into gross negligence, and that's a different cause of action. And you had one before, and the one they gave you didn't have. But if you separate that from the statute of limitations issue, even if you were to succeed on that, you're still outside the statute of limitations, weren't you? Like, do you winning this argument rely on us to find those two issues inseparable?
No, I mean, she survived her motion to dismiss.
Correct, but what I'm saying is on summary, you were found not to survive the statute of limitations, correct? You didn't meet the statute of limitations.
Right.
And so what I'm saying
The
is,
new statute. of limitations.
yeah, correct. And so what I'm saying is, if we think the statute of limitations part is okay, right, that is fine under bold, but there's nothing we can do about that, even if we disagree with it. I'm not saying we do, but it's just here, neither there, because the Supreme Court said it. Doesn't that make the gross negligence issue moot?
No, because the statute either applies retroactively or it doesn't apply, and you look at the statute as a whole. So if you apply the statute retroactively, then she loses under the gross negligence, failure to plead gross negligence, and the failure to meet the new statute of limitations. If you don't apply the statute retroactively as a whole, then she survives her motion to dismiss.
So even though your case, you may lose under a part of the statute that would be valid on its own, right?
If it's valid on its own.
Right, if it's valid, that's what Bold says it is. You think you can still win another part of the statute that you may have a good argument on, but you will still lose under the statute of limitations? Like, I guess we have to keep those together.
So prior to the application of the statute, she was under 766. And she was compliant with both the statute of limitations and she had set forth a valid claim for negligence. So the 768, 381 wouldn't come into play at all because it wouldn't apply to her either. Any of the provisions would apply to her. None of those provisions that were enacted after her cause of action accrued would apply, whether they were separated out or not.
I guess what I'm saying is,
Whole.
if it's improperly retroactive based on a provision that doesn't apply to your client, right, that just isn't effective for case, you still think you win?
Yes, because the statute is viewed as a whole. And so that the retroactive application absolutely affected her rights, both in terms of the statute of limitations and the statute, the pleading argument as well. So yes, I think that's what Mendez requires. I think that's what this court in Hughes requires, that you look at the statute for all of the provision.
Wasn't there a footnote in Hughes that talked about that things can be separable, but we just didn't have to address it in that case, and the court didn't have to address it because of the posture of that case? I'm trying to remember the details, but I guess what I'm saying is I'm not sure the issues are inseparable or unseverable as you're arguing. And I think there might have been something, I could be confusing with another opinion, but I think Hughes actually addressed the fact that sometimes issues can be severable, but in that case, the severability didn't matter, wasn't an issue. Like, does Hughes say issues that statutes are unseverable when one part is proper and procedural, like the statute of limitations, one part might be improper, such as changing negligence to gross negligence?
I think Hughes says you look at the statute as a whole, the way I recall reading it, and then you determine whether the statute is substantive in nature or, in that case, it gave safe harbor to the insurance.
But in Hughes, all those provisions were interlinked. Whereas here, these two seem to be two completely separate provisions that could stand alone.
Well, it's actually more than two separate standard provisions, because it's actually a third, because now there's a greater burden of proof to prove that it wasn't COVID-19 related. So it's before she didn't have to prove what her husband had or didn't have in order to bring a negligence claim. So and then there's also affirmative defenses that are in the statute that weren't specifically pled by the defendants, but those.
Are any of those like interoperable with the statute of limitations? It seems to me the statute of limitations provision could stand completely on its own.
But it's viewed as a whole. The statute, I keep going back to that. It's my understanding that the statute is viewed as a whole and that you can't separate it out. And even if you did separate it out, the substantive issues that affected her and vested right would prevent the whole statute from applying to it.
Counsel, you're in your rebuttal time.
May it please the court, I'm Marie Borland from the Hill Warden Henderson firm in Tampa, representing the Lakeland Regional Medical Center. I'm here today with Mr. Ted Copeland, who represents the individual physicians, and I'll be presenting an argument for all the defendants. So on the constitutional issue, I think what maybe the confusion is, I think what counsel is saying is when she says views as a whole, I think she's making a facial challenge to the entire statute, not an as applied. And of course, this court knows that that is about the hardest thing to overcome. So, we've relied on the Planned Parenthood, the principle that has been laid out in a lot of Supreme Court cases, most recently perhaps in Planned Parenthood, that of course, when you're looking at a statute, there's a presumption of constitutionality. All doubts have to be resolved in favor of constitutionality. And if there are two interpretations of a statute, one that affects a constitutional outcome and one that does not, the court must apply the outcome that does affect a constitutional outcome. So that's what we're arguing today. And I think what Your Honor said, Judge Mize, that I think it applies here, that, and it's exactly the way I thought about this as I was preparing, that she fails on this statute of limitations test. So we don't really have to get to the standard of proof the way the legislature has talked about it. So we know that in the Bald case that simply shortening a statute of limitations does not take away a vested right. I didn't find anything, and I looked on whether you impose a higher level of negligence, whether that's a vested right, but I would say I think that is just laying down conditions upon the exercise of a right, the same way the Bald case talked about with the statute of limitations. So we would submit if this is a substantive challenge to the statute that has been made, that it certainly satisfies a retroactivity test that legislature has plainly stated an
I
intent.
have two questions for you.
Mhm.
Number one, you made a preservation argument that the appellant's argument wasn't preserved because the trial court didn't expressly rule on it.
Yes.
I've never heard of that being the standard. I mean, if the appellant makes the argument to the trial court, we think it's preserved, right? The appellant can't control what basis the trial court chooses to rule on. Otherwise, a party could make the argument as specific as possible until they're blue in the face, right? Over and over again at every opportunity. And the trial court could prevent it from being preserved just by not expressly ruling on that particular argument and ruling on some different argument.
Well,
Well, can I ask a follow-up to that? Because it's also a preservation problem that I had with your argument. Is it not implicit in the trial court's ruling that they denied or they ruled against the plaintiff on the idea that this could not be retroactively applied? They had to reject the constitutional argument that the plaintiff made in order to apply the statute of limitations.
well, okay, not exactly. And I understand what both of you are saying, and I was going to rest on the briefs because I think the court's more concerned about the substantive issue. But so we've cited, I think, 2, if not 3 cases that say you have to have an express ruling from the trial court. So it would seem at first blush when the court said at the motion to dismiss hearing, I can apply the statute retroactively. The only argument that had been made at the motion to dismiss hearing was that there was not, I think there was not a clear intent for it to apply.
Do those cases stand for the proposition that the trial court has to rule on a particular argument or on the issue the argument pertains to? In other words, if you make 3 arguments to a trial court in favor of rule this way for reasons A, B, and C. Okay. And the trial court says, I agree with you on A. And therefore, I'm not gonna reach B and C. Are you telling me B and C aren't preserved?
No, if you're the appellant, well, certainly if you're the appellee, then you can make a Dixie coachman argument and say, well, the court was right for the wrong reason, B and C would have applied. I don't know, I haven't considered whether, it's hard to imagine without knowing what the A, B, and C would be. But I would say the difference in this case is there are two prongs to the constitutional test. One is, was there an intent for retroactivity to apply? That we believe the court has ruled on. But the second one, which is most heavily relied on in this case, is, was there an impairment of a vested right? That the trial court never ruled on. So if this court were to say, well, we think the trial court got it right on retroactivity, sure, the trial court ruled on that. This court can't say, I don't believe, this court can say that the trial court got it wrong on vested rights because no ruling, no express ruling was ever made. So it's our
But
position.
would be saying the trial court got it wrong on retroactivity, right? And vested right was one of the legal arguments made.
They're two separate issues. They're two separate elements. In this case, you could look at this constitutional issue as a cause of action, and you have to plead or you have to prove these two elements. If you are saying you think that, the statute is unconstitutional, one, that there's not an intent to apply retroactively, and two, that it impairs a vested right. You have to prove both of those. Of course, I don't want to spend too much time on this, and I would rely on the briefs on this, and I don't think it's
Council,
dispositive.
we're asking you about it, so we want to
Right.
spend some time on it.
No,
We asked you about it, we expect you to spend time on
But,
it.
but again, we have cited cases, and it's my experience as an appellate lawyer that an appellate court is going to review a ruling by a trial court. So this court is certainly able to review the ruling of the trial court that there was an express intent to apply the statute retroactively because the court ruled on that. But the bigger argument was, okay, well, even if that's true, was there an impairment of a vested right? I don't think you'll find anywhere in the summary judgment order in the transcript where the court addressed that specific argument. We don't think there's a ruling.
So I guess what I'm saying, Council, the ruling is the statute applies retroactively, right? And
The ruling was he could apply the statute retroactively. That was one element of the test, but he did not expressly rule on the bigger issue, and that is, did it impair a vested right?
well, to find the statute retroactive, you have the two elements of was there retroactive intent and did it not impair a vested right by doing it, right?
Well, I think if you review the transcript and you review the order, you won't see anything from the judge about that.
Well, but that goes to Judge Nardella's question. How do you apply the statute retroactively without at least implicitly finding that it wouldn't impair a vested right?
Well, that's what this court would have to find, that the court implicitly made the determination in the court's mind without articulating it, that not only was there an intent expressed in the statute to apply it retroactively, but that it also didn't impair vested rights. As an appellate lawyer, I'm simply saying that I don't believe that ruling appears on the record. And I would say, as a matter of procedure, appellate procedure, I don't think that issue is properly before this court.
So then you think it is, if a person makes an argument over and over, as specifically as possible, till they're blue in the face, right, at every possible opportunity. And the trial court there's, multiple legal arguments that pertain to an issue the trial court has to decide, and the trial court doesn't speak to that specific argument. The attorney, the party, there's nothing they could do about that. They made the argument over and over and over again, till they lost their voice, till their hands were crippled from typing. And the trial judge could just decide it wasn't preserved by not addressing it.
No, Your Honor, and I'll use that as an example. Say I'm arguing a negligence case and the court says, okay, I represent the defendant. I find there was a duty, therefore you're liable. And I would say, well, no, because you also have to find there was causation and damages. So it's an element. What I'm saying, it's an element. If I'm the trial lawyer and I have multiple elements that need to be proven for whatever position, whether against me or in favor of me, and the court has simply made a determination without going through every single element,
But
I'm
isn't
not
that
to be concerned that when I go up on appeal and I say, well, the court was wrong on causation. Well, where's the causation ruling? That's all we're saying. It's as simple as that. We don't believe there's any ruling by the court on whether there was an impairment of vested rights for this court to review.
But how did you get a ruling? So in this case, if the trial judge decides could be retroactive, right, dismisses the case. They can't make the trial judge issue a new order, because there's been an order, the trial judge issued the order on the motion for summary judgment, right? That order is issued. It's not like they can mandamus the trial judge to, hey, expand your order, type more.
No,
What could the person do?
at the hearing, when the court says at the end of the hearing, in this case, for example, the court says, okay, I'm going to find that the statute can be applied. Your Honor, with all due respect, it is my obligation as a lawyer to preserve the issue, to obtain a ruling from you. So we are asking you,
If the trial court says, I don't think that's necessary.
you have then preserved your argument. When you ask the court for, this is my understanding of case law. If the trial court has not issued a ruling on an issue that you want to take up on appeal, then it is your obligation as a lawyer to ask the trial court to visit that particular issue. And if you've asked the court to do that, and the court says, I've made my ruling and I'm not going to go any further, then you have preserved the argument.
What if the trial court, oh, sorry, go
Okay.
ahead. What if the trial court had reserved ruling and not ruled at the hearing and issued a written ruling after? Would a motion for rehearing be required then to
I-
preserve it?
If I'm being as careful as I possibly can as a lawyer, I would move for rehearing. It's, to me, it's a basic principle of preservation law. But again, if that's the court's main concern, I mean, I think the bigger issue is this court is being asked to find a statute facially unconstitutional. And I think in this case, there are not grounds. It would be in violation of the Planned Parenthood, the test for constitutionality articulated in Planned Parenthood. There's intent to apply retroactively. There's not an impairment of a vested right. The plaintiff still has a cause of action for negligence and wrongful death. There have just been some conditions laid down on that, as the Ball court said was appropriate. So,
Counsel, can we talk about intent? The intent that's being argued by your opponent is an editor's note. Is that a permissible resource for us to look at for legislative intent? Are we confined just to the words of the actual statute itself? What world are we looking at when we try to divine legislative intent for this test?
well, I mean, the rule of statutory construction is the court starts with the plain language of the text of the statute. And so we would say here, the plain language of the text of the statute expresses a clear intent to apply retroactively. So that's where I would say that the court would start in this case, is with the text, because that is the rule of statutory construction.
Let's say the editor's note is directly on point. It says exactly opposite of what the text says. What wins out?
In that case, maybe you look at legislative history, you look at other principles of statutory construction you would bring into play if that were the case, which is not the case here. So in this case, what we briefed is this particular statute evidences a plain intent to apply retroactively. So for that reason, the retroactive, we agree the trial court ruled correctly on that issue as a matter of law. So I hope that answers Your Honor's question, that here we would be looking at the text of the statute. Does the court have any additional questions on the constitutional issues?
You just address the change from negligence to gross negligence. That doesn't seem like a burden of proof to me.
We didn't say that in our brief. I mean, we said that the statute called it a quote standard of proof. I think it is just an elevated showing that has to be made, as Your Honor has recognized. I think it's preponderance of the evidence is, I think, what the statute now requires. So again, that's not the position that we took, but we've taken the position that that doesn't impair a vested right. And as Your Honor has said, even that issue is not really before the court, because in this case, the plaintiff loses on statute of limitations, which we know from the Ball case is a permissible change in a statute. So I don't have much more to add about the gross negligence other than to say that we don't think the court really needs to get to that because it's not the issue in this case.
Counsel, what's your response to their reading of Hughes?
I'm sorry.
What is your response to their reading of Hughes? Do we look at the entire statute as a whole to determine if there's an impairment? Do we look just to the subsection which is being challenged? Why?
So I would say when they say look at the statute as a whole, I think what they're saying, this is a facial challenge. This is a challenge to the statute on its face, every provision. And I think that's what counsel has said. And in talking to the court about the Hughes case, the court knows that a facial challenge is a very, very serious matter. And we don't believe that a facial challenge is appropriate here. We don't believe the court has to look at all the provisions of the statute, because in this case, what doomed the plaintiff's case was a limitation statute. So I don't believe this court has to or should strike down this statute as unconstitutional on its face, which is what the plaintiff is asking this court to do. And we would say that for the court to do that, it would be going against the Florida Supreme Court authority and the test laid down by the Florida Supreme Court. That is a very serious matter, as the court well knows. So to answer your Honor's question, I don't think we have to look at the statute as a whole. I don't think a facial challenge is appropriate in this case. So I think we can look at the limitations. And we know from Ball that that was a permissible change in the statute, and that defeats the plaintiff's cause of action. Any more questions on the constitutional?
No, counsel.
I know my opponent did not get into the second issue, which is, and I don't know if the court would like me to address that because it was not addressed in the main argument, but we would simply say that we believe the court applied federal summary judgment standard correctly, that the court correctly found it's undisputed, that the negligence in this, or the alleged negligence in this case, which was the insertion of the feeding tube, that arose out of treatment for COVID. I think it's undisputed that Mr. Mascarenhas admitted to the hospital with a severe case of COVID. He was treated for COVID throughout. Dr. Meyer has said that he was intubated and the feeding tube was required because of his COVID. His death certificate says he died of COVID pneumonia. So I know there was an identification of two separate items of evidence, and that was Dr. Meyer's testimony that in general, the insertion of the feeding tube is not necessarily required for COVID. That's true, it was here. And then Dr. Patel, the affidavit saying that he was intubated and the feeding tube was inserted because of pneumonia. It was COVID pneumonia. So we don't think there's any dispute that this case arose out, the alleged negligence in this case arose out of the treatment of COVID, that it therefore falls within the four corners of the statute. And we would ask this court to affirm the trial court on both issues.
Counsel, I noticed that the language under subpart 5A, which is the limitations period, versus the definition of COVID-19 related claim under 1D, the language is a little bit different. The prepositions are different. There's arises from a person for COVID versus arises out of. I'm just wondering if you think that they mean the same thing, or if this difference in language means anything, like one provision is narrower than the other.
So Your Honor is saying, so when the definition of COVID-19 related claim arises from the ... treatment of a person for COVID.
Yeah, like there's a list of things under the general definition
Right.
to it, but then it uses that phrase, but then goes on under the limitations period, if that means anything, if it narrows it at all.
I don't think so, because on the limitations, it says an action for a COVID-19 related claim ... which arises out of the treatment of COVID-19. I think for purposes, certainly for purposes of this case, I think the language is identical. And I don't think that there was any intent for that not to be sort of a mirror image what the legislature meant in talking about a COVID-19 claim.
I don't have any further
All right.
questions.
Well, I appreciate the court's time. And again, we would ask this court to affirm. Thank you.
Just to follow up on the question about the intent and the clarity of the intent. So if the law is clear that if the legislature's intent is unclear, then it goes against the retroactive application.
Can you repeat that, counsel? I didn't follow.
I'm convoluted. So the law is clear that in order to apply the statute retroactively, the two-step test is that the legislature has to be clear. And when the legislature in its comment is not clear about the retroactive application, then it should not be applied retroactively.
I understand your position from a logical standpoint. Current case law, where do we look for legislative intent? Do we look outside the plain language of the statute itself? And can you cite me, is there any authority you can send me to that would tell me to look at the comments?
Nothing comes to mind that the plain language, that the court can go outside of the plain language.
Would you concede, I guess you're not going to concede, but why is the plain language of, why is it not plain from the language of the statute that it's intended to apply retroactively? If you don't have the editor's note, what's your best argument just based upon the statutory language that makes it unclear?
Well, the editor's note came from the legislative bill, and I think that.
No, that wasn't the question. The question was, absent the editor's note, just based on the statutory language, what's your best argument?
Well, the editor's note in the statute,
Counsel, it's a simple question. Ignore the editor's note. Only based on the language of the statute. What is your best argument that it does not show clear evidence of retroactive impact?
that if you ignore the notes that were in the legislative bill and on the statute, then then the argument would be, as it's written in the statute.
So if you just based on the language of the statute, there's no good argument that it's not clear evidence of retroactive impact, right?
That it's intended to apply retroactively.
Yeah.
Yeah.
Counsel, I did find the part of Hughes I was thinking about. It's footnote 4. And we basically said that there was a change in the attorney's fees. And because we determined that this 627-70152 is substantive and cannot be applied retroactively, even without considering the changes to the method of calculating attorney's fee, we need not consider whether the attorney fees are severable for purposes of the determining whether a substantive vested right is effective. I think that kind of addresses your argument about the fact that things cannot be severable. I mean, I think you interpret the statute as a whole, but that doesn't mean individual provisions, how you interpret them may affect on this, look at the statute as a whole. But individual provisions, I think, could be severable. I think we acknowledge that in Hughes for purposes of determining retroactivity.
Well, my response to that would be the principle of retroactivity and the constitutionality of whether statute can be applied retroactively deals with whether the statute impairs a particular litigant's vested right. And it's clear that her rights were basically, they were extinguished when she
But
put
at least as
COVID
to the
into
statute
play.
of limitations, Bold says that's okay, right? So if the statute of limitations is severable, then whether or not the negligence, gross negligence change would harm your client or be impermissible as substantive, it doesn't really matter because the statute of limitations provision is okay under Bold, and that would foreclose your client's claims because you were outside the statute of limitations.
But that's only because the COVID applied, the COVID-19 applied. So if you don't apply COVID-19, you don't get to the new statute of limitations.
Well, but counsel, the statute of limitations, I grant you, it limited the statute of limitations for a subset of claims relating to COVID, right?
Right.
But that is still. That is still, it only changed it for a subset. I'll grant you, it didn't change it for all negligence claims. But that is still changing the statute of limitations for a specific subset of claims. So like, for any statute of limitations, the issue is whether you've fallen in it, right? So I don't know just the fact that the statute of limitations change is only for a subset of claims as opposed to all claims helps you.
Well, I believe it helps because when you look at what happened to her, it extinguished that the application of that statute extinguished her right. And both because of the gross negligence, failure to plead gross negligence, the failure to prove that she didn't have COVID-19, and then the statute of limitations. So the combination of that application of that statute is what impacted her vested rights. And in terms of, if just real quick, on terms of Dr. Meyer's deposition that the plaintiff put in to indicate that there's a dispute of material fact, he was asked specifically whether the cause of action, basically insertion of the small bowel feeding tube into the lung was causally related or arose from, pretty much. And he said the reason for the feeding tube was not because of its respiratory infection. And that's the defendant being questioned by the defense attorney.
Thank you, counsel. Are there any further questions? You're out of time. Thank you both for your briefing and for your